National real estate questions. That's what we're reviewing tonight for the real estate exam. So let's get started. And I'm using the same book, the Texas Real Estate. Let me see here. This book, oops, I guess I should share. So we're using this book and doing only national questions. All right, so let's get to it. We're starting with question number 336. And this section has to do with land use, legal descriptions, and contract law, but contract law for national, okay, not for a particular state. All right, let me make this a little bit larger. That way everybody can see it on your phone. Would love for you to participate by typing the question number and the letter answer in the comment box below. And I will help you to understand it if for some reason it's incorrect. And if you got it correct, I'll say woohoo. All right, number 36. An implied agency relationship may be deemed to exist if A, the parties do not disavow an express contract that has expired. B, the parties act if there is a contract. C, an offering party does not receive written notice that the offer has been rejected. Or D, the parties promise to perform their part of the agreement if the other party performs. So anybody want to take a shot at it? So the answer for 336 is B. The parties act as if there is a contract. So the question was an implied agency relationship. Implied, right? So it wasn't verbally said that there's an agency relationship. It's like, I didn't say I represent you. Okay, you are my client. It's implied. And they act as if there is a contract. B, the parties act if there is a contract. Of course, it has to then be put in writing with the buyer or seller representation agreement. Okay, number 37. Which of the following is an executory contract? Okay, vocabulary, okay? Executory, well, implied agency also on the prior question, okay, is vocabulary, disavow. So executory contract, there's executed contract and there's executory contract. There is a difference. So A, an expired lease. B, a sale contract before closing. C, a recorded sale contract. Or D, an option to buy after it is exercised. What is the answer for number 37? The answer is B. An executory contract is a contract before closing. So the contract has already been signed by both parties, and it is with the closing officer, the escrow officer, be it a title company or an attorney, because both of those can process a closing. And so when it's executed, it's when the buyer and the seller sign the agreement and the realtor has put the executed date on it as to when it was signed. In some states, it requires to put the time and the date that everybody signs, just in case there's any confusion. And both parties must be informed. Once it's executed with both parties signing and the realtor executing the page, then it goes to the title company or the escrow officer. Let me rephrase that. And it is now a sale contract going towards the closing process. So let me see here. It's another way to say it is an executory contract is one in which performance is yet to be completed, meaning both parties have to follow through to close the transaction, right? The seller going through the allowing the buyer their option period if they ask for that. So the buyer going through that option period, which is the due diligence inspection. A sales contract prior to closing is executory. While the parties have agreed to buy and sell, the buyer has yet to pay the seller, and the seller has yet to deed the property to the buyer. That's how the book states it. We're on what, 38? Okay. Number 38, a bilateral contract. Vocabulary, bilateral. There's unilateral and bilateral. Is one in which what? A, both parties promise to do something in exchange for the other party's performance. 2, both parties receive equal consideration. C, two parties agree to perform a service together. Or D, both parties promise to do something if the other party performs first. So what do you think the answer is for 338? So Max, are you here from North Dakota? You've been texting me yesterday. I had appointments yesterday, so my apologies. So the answer for 338 is A. Both parties promise to do something in exchange for the other party's performance. So the seller has agreed to sell at the agreed upon price and convey the deed, transfer the deed to the buyer, and the buyer has promised to also perform by making sure they get final approval by the lender, the lender accepts survey and the appraisal, and it closes and the money's in the bank. Okay, that is the performance that both the seller promises to transfer the property, the buyer promises to pay for the loan amount, the purchase amount. So both parties have to perform, and that's called specific performance. Vocabulary. Have any of you been reviewing vocabulary? Just curious, because it's a must. A home seller signs 339. A home seller signs a listing agreement with a broker. Oh, let me move that to the bottom. With a broker, then subsequently revokes the list agreement with a broker, then subsequently revokes the listing. So they cancel the listing, right? Which of the following is true? A, the seller continues to have contractual obligations to the broker. B, the contract remains in full force until the expiration date. C, the broker may have a claim for marketing expenses during the listing term, expenses expended during the listing term. Or D, the seller cannot sign a listing agreement with another broker. So answer for 339. What do you think happens when a seller signed a listing agreement, but they changed their mind, right? They have a right to change their mind, but there could be consequences. So yes, there is a consequence. C, the broker may have a claim. So it says may have. Doesn't say they have, because maybe they haven't spent any money yet on marketing. So may have a claim for marketing expenses expended during the listing term. So the damaged party, which would be the broker, may elect the following legal remedies: rescission, forfeiture, suit for damages, or suit for specific performance. However, the broker must show that the seller has breached the contract. It doesn't say how soon or at what time of the listing agreement the seller revoked, it just says that the seller revokes the listing. Didn't give a date, didn't give a time. If it's done like 3 months after, well, there's been expenditures. If it's done once there's an offer, well, the broker and the realtor have done their performance, right? That's what they were hired for. So the seller could be required to pay the commission because they're supposed to perform, right? They agreed to sell the property and get an offer. Now, they don't have to accept the offer. However, if it's a full price offer, excellent terms, everything, they just changed their mind not to sell, then there are consequences, and the damages could be paying the commission. The broker could sue for performance. The buyer could sue for performance. Okay, because the question doesn't say, when they canceled it. It just says subsequently revokes the listing. So the answer here was C, right? Or is C. The broker may have a claim for marketing expenses expended during the listing term. So be very careful. Pay attention to what the question says before you jump to select an answer. Okay, number 40, pardon me. A breach of contract. Vocabulary. What is a breach? A termination of the contract by the mutual consent of the parties. B, financial damage suffered by a party because another party has nullified a contract provision. So that's a vocabulary there, not nullified, mutual consent. A lawsuit to force a party to discharge the contract. What's discharge? Or D, the failure of a party to perform according to the terms of the contract. So when a contract is breached, what does that mean? Nobody wants to participate. Come on, you all. Participate and let's each other interact, and let me help you if you have questions on it. So the answer here for 340 is D, the failure of a party to perform according to the terms of the contract. So it could be, the listing contract, or here, a listing is called the listing agreement, but it's also a contract, right? It's an agreement, has a start and an end date. And a purchase and sale agreement is a contract signed by the buyer and the seller and executed by the last realtor that received notice and acknowledgement and provides that notice and acknowledgement to the seller. Or to the buyer, whichever party did, because it could go back and forth with counter offers. So the book says a breach of contract is a failure to perform according to the terms of the agreement. No big deal. That's what it says. Number 41. What is a rescission? Oh, there's a delay on YouTube. What is rescission? A, the act of withdrawing an offer before it has been accepted. B, the act of declaring that a contract is no longer in effect for a given party. C, the act of declaring a contract unenforceable. Or D, the act of modifying the terms of an offer. What is rescission? Again, that is a vocabulary. See how there are so many vocabularies in the questions, and when we know the vocabulary, it makes it a lot easier to select the right answer. But please always read all the answers. Don't jump to a conclusion and select an answer, because I have made that mistake. And sometimes select the wrong answer because I didn't read them all. So the answer here to 341 is B as in boy. The act of declaring that a contract is no longer in effect for a given party. So it was rescinded. So parties to a contract may rescind a contract by mutual consent. Both have to agree, or a damaged party may rescind the contract unilaterally. Unilaterally is in one direction, right? This act of rescission cancels the contract and returns the party to their pre-contract condition, including the refunding of any monies already transferred. So if the buyer rescinds the a contract before the option period expires, before 5 o'clock on the option period expiration date, and it used to be midnight in some states, but hey, banks aren't open after, at midnight. Neither are lenders. Well, lenders might be. Title companies aren't. Inspectors, all those. So it was changed to 5 p.m. One party may terminate the contract, rescind it during the option period, or even just after an agreement. So parties to a contract may rescind a contract by mutual consent. Mutual consent if they both agree. Or a damaged party may rescind the contract unilaterally. The buyer may have suffered losing the earnest money. Okay, they terminated it, and the damages are the seller keeps the earnest money. This is an act of rescission, cancels the contract, and returns the parties to their pre-contract condition, including the refunding of any monies, if there is a refund. And if there is a release of earnest money or any other type of refund, it has to be done in writing. Both parties have to sign to release that money from the title company or the attorney, whoever acts as an escrow officer. So 341B. Oops, that's not going to work. $342. To be valid, a valid contract must include certain things. What are they? A, reflect a mutual understanding or agreement. B, use precise wording in a document. C, not be executable. Or D, be created only by an attorney. What is the answer for 342? I almost said the answer. The answer here is A. To be valid, a valid contract must reflect a mutual understanding or agreement. Now, there are other things that are required for a contract to be valid, but it didn't give those options, right? So it must be in writing in order to be enforceable. If it's an offer and sale purchase, there must be a consideration, which is not required to be cash, right? So on here, they didn't give you those choices. They didn't give us those choices. They just said, A, reflect a mutual understanding or agreement, which is true. Use precise wording in a document. Well, they're templates. The wording is already there. Not be executable. Wrong. It has to be executed. To be valid, have to have a start and an end date. Be created only by an attorney. Incorrect. The documents are created by attorneys and brokers and a public person, at least in Texas. I'm not sure about all other states in the U.S. However, if the purchaser is an investor, a lot of times they will use their own contracts that are created by attorneys, and that is doable. Okay, 342 is A. Number 4, anybody who just came in, we are doing national questions. That applies to all 50 states. Two parties enter into a contract. The agreement fulfills all the requirements for a valid contract with no disqualifying circumstances. Given this situation, it is still possible that the contract may be what? A, void, B, illegal, C, unenforceable, or D, voidable? Even though it's a valid contract, okay, it's signed by both parties, it has a valid start and end date, it has um, a condition, a consideration. Gosh, I'm forgetting words today. What do you think still, given the situation, it's still possible that the contract may be what? Void, illegal, unenforceable, or voidable? The answer here for 343 is C. It is it can be unenforceable. It may be unenforceable. A valid contract that is in writing is enforceable within a statutory time period, start and end date, right? A valid contract that is made orally is also generally enforceable within a statutory period, with the exception that some contracts are enforceable only if they are in writing. A lease agreement to be enforceable must be 1 year. If it's verbal, it's less than 1 year. These laws apply in particular to the transfer of interest in real estate. A void or voidable contract was not a truly valid contract. Okay, so it's not void because it was legal. Okay, it was valid. It wasn't illegal, and it's not voidable. So it's unenforceable. It was the answer here. Because the question had two parties into a contract, right? You normally need two parties minimum. The agreement fulfills all the requirements, no disqualifying circumstances. Given this situation, it is possible that the contract may be unenforceable. Let's see, what else does it say? So yeah, a void or voidable contract was not truly a valid contract. Like if somebody is underage, illegal means it's, crime money or whatever other type of, it's not a valid contract. All right, number 44. The guardian for a mentally incompetent party enters into an oral agreement with another party to buy a trade fixture on behalf of the incompetent party. Oh, so if one of the parties is incompetent, they find out that they're incompetent, then it's unenforceable and they can void it. Okay, again, the guardian for a mentally incompetent party enters into an oral contract with another party to buy a trade fixture on behalf of the incompetent party. This contract is, so the guardian, right? The mentally incompetent party has a guardian. They enter into an oral agreement with another party to buy a trade fixture on behalf of the incompetent person. This contract is what? A, does not meet valid and enforceable. C, must be in writing to be valid. Or D, is valid but unenforceable. Okay, the answer here is B, is possibly valid and enforceable. Okay, because the decision-making person is the guardian, and they would have a power of attorney to make decisions for the incompetent party. Let's see what it says on here. Incompetent parties or parties of unsound mind may not enter into enforceable contracts. However, during the period of one's incompetency, a court may appoint a guardian who may act on the incompetent party's behalf with court approval. And so that's an administrator. If they have a will and a trust, it's an executor, right? Okay, number 35. I'm sorry, 45. And probably not going to show yet. Okay, number 45. A prospective home buyer submits a signed offer with the condition that the seller pay for the inspection at closing. The seller disagrees, crosses out the provision, then signs and returns the document to the buyer. At this point, assuming all other contract validity items are in order, the original offer is now what? A, an accepted offer, therefore a valid contract. B, an executable option. C, a counter offer. Or D, an invalid offer. So a seller received an offer with a condition that the buyer wants a seller to pay for the closing. So the seller doesn't agree, right? The seller disagrees. So what is this considered? It's not an acceptance. The answer is C. It is a counter offer. So by changing any of the terms in an offer, the offeree creates a counter offer and the original offer is void. At this point, the offeree becomes the offerer and the new offeree gains the right of acceptance, which is the buyer. If accepted, the counteroffer becomes a valid contract provided all party requirements are met. Both have signed and a realtor executes it after both parties sign. Any questions? I don't see any. Right, number 46. A construction contractor executes a contract with a buyer. In the agreement, the contractor promises to complete construction by November 20th. This promise can be construed as A, an option, B, mutual consent, C, meeting of the minds, or D, valuable consideration. So construction contractor executes a contract with a buyer. So a lot of contractors have their own office and have their own representative, and they sign the contract. And the buyer may not have their own realtor. They might just go with them. So in the agreement, the contractor promises, right? Promises to complete construction by November 20th. This promise can be construed as 346, the answer is D. It is valuable consideration. So that is what the contractor is providing. So the buyer is probably putting down an earnest money, and that's their consideration, and the contractor valuable consideration and commitment is November 20th. That is a duration. So let's see what it says here. Valuable consideration can be something of tangible value. Okay, it doesn't have to be money, such as money or something a party promises to do or not do. For example, a home builder may promise to build a house for a party as consideration for receiving money from the home buyer. Number 37, 47. I like it when it's big. There we go. A seller contracts to sell a property that she does not own. Okay, so seller contracts to sell a property that she does not own. The sale contract for this transaction is what? A, executable. B, must be in writing. C, is void. Or D, is illegal yet potentially enforceable. So who can sign who can sell a property? Can anybody sell somebody else's property? No, right? So the answer here is C. The contract is void because that seller that is trying to sell somebody a property that she doesn't own is not theirs. They have to prove that they are the owner of the property and have the right to convey the deed, transfer the deed to the new buyer, to the new owner. So 347, the answer is C. And thank you for being here. I appreciate it. I didn't give much notice, but most of the time I don't. I just go live and I post it on, it shows up on YouTube and Facebook. I didn't post it there, and on my different messenger groups. Okay, number 48. The statute of limitations, definitions, requires that parties to a contract who have been damaged or who question the contract's provisions must what? A. Okay, all the answers have a word must, so one of them must be right. A lot of times the words must, always, never, only are incorrect answers, but in this case they all have the word must. A. Must act within a statutory period. B. Must select a specific limited course of action for recouping their losses. C. Must arbitrate prior to taking court action. Or D. Must wait a statutory period before they may take legal action. Anybody? 348. Answer for 348 is A. So the statute of limitation requires that parties to a contract who have been damaged or who question the contract's provisions, A, must act within a statutory period. One example is to put a mechanic's lien. They have, I think it's up to 75 days to record a mechanic's lien, and they'll inform, the contractors will inform the person that hired them that, hey, if they don't get paid, they're going to record a mechanic's lien. So that lien will be attached to that property, but it has to be done during the statutory period. And when that property ever gets sold, then the mechanic's lien will get paid. Doesn't always get paid 100% if there isn't enough money, because the priority of liens is one, property taxes, and then the primary loan. Loan number one. If there's a second loan, then that one, and then comes other liens. So know your priority of liens. Property taxes are always first. Oh, I wish it would allow me to edit the answers. I didn't type the pardon me, I didn't type the number correctly. So the answer is 348A. Number 49. Let me see if it'll, a little bit of internet interruption. The purpose of the statute of frauds is to A, invalidate certain oral contracts. B, require certain conveyance-related contracts to be in writing. C, nullify oral leases and listing agreements. Or D, eliminate fraud in real estate contracts. The statute of frauds is for what? What is the purpose of the statute of frauds? No one, huh? So 349 is B as in boy. Require certain conveyance-related contracts to be in writing. So contracts that are going to sell a property, buy a property, and something's going to be conveyed, and leases must be in writing. So statute of fraud protects individuals that go into contracts. Public. It also protects the investors. However, investors are supposed to be more knowledgeable, especially when it comes to leasing. All right, let's see if it says anything different here. So the mutual consent required for a valid contract. Oh, I'm sorry, wrong answer. The statute of fraud requires that certain contracts must be in writing. What? Must be in writing. Real estate contracts that convey an interest in real property. What is real property? The improvements and the land, or just land, right? Fall in this category, with the exception that a lease of 1 year's duration or less may be oral. Number 50. A seller immediately accepts a buyer's offer, but waits 10 days before returning the accepted document to the buyer. Meanwhile, the offer has expired. Which of the following is true? Okay, so the question says, a seller immediately accepts a buyer's offer, but waits 10 days before returning the accepted document to the buyer. Meanwhile, the offer has expired. Some contracts will have a deadline as to when the offer should be accepted or rejected or countered. So some of them have a deadline as far as when to respond. Some places it just says within a reasonable time. So which of the following is true? A, the buyer is bound to the contract since it was accepted immediately. B, the buyer has no obligation to the seller whatsoever. C, the buyer may not rescind the expired offer. Or D, the seller may sue for specific performance. What is the answer for 350? What was the key word? Offer expired. Once it expired, there's no contract, right? So the answer is B. The buyer has no obligation to the seller whatsoever, because the seller, YouTube rejected your comment. What? That's, oh, try changing it a bit. Okay, something I said wasn't acceptable. But for some reason, it's not showing my answer. Can't post comments to some destinations. Okay, let me try it again. So 350 is B as in boy. Okay, there we go. All right, so we've done 40 minutes and we've done what, 14 or 15 questions. How about we do 5 more? Since we're only doing national today. Number 51. A deed restriction limits how owners may use a property within a given subdivision. One key characteristic of a deed restriction is that deed restriction is different than zoning restrictions, city restrictions or county restrictions. So a deed restriction means there are additional restrictions that are set within the deed for development. One key characteristic of a deed restriction is that it, A, may be revoked by an owner, B, may be exempt from ADA restrictions, C, may not be discriminatory, or D, may not apply to protected classes vis-a-vis fair housing laws. So the answer for 351 is C. It may not be discriminatory. Oh my gosh. Try changing it a bit. So the answer is C, may not be discriminatory. I'm just reading what it says there, but YouTube didn't like it. So HOAs, whenever there's a subdivision, zoning restrictions, then there would be an HOA and the deed restrictions that are delivered, the bylaws that are delivered to anybody that purchases a property or is getting ready to purchase a property on there. They may want all homes to be 3-bedroom, 3-bath, 2-car garage, 2-story, brick. Those are deed restrictions. The city only said, hey, you can, well, the developer will add additional ones. Huh. Are the answers showing? Let me see here. So some of them, 351 didn't show up again. Okay, there we go. Okay, so that was supposed to be 350. Pardon me. Yes, okay. May not be discriminatory. Must use caution in developing restrictions for a new subdivision's land use regulations. In particular, no restriction may be discriminatory, such as an improper resident age requirement, nor can the restriction violate fair trade laws. Now, if it's a 55 plus community, then they have to apply to have a 55 plus type of community. Otherwise, they would not be able to put restrictions on who can live in that community, in that subdivision. Okay, we're going to call it quits because the next section starts with agency and listing agreement. So we'll start test number 4 in the next session. Any questions? So the material that we just covered had to do with land use, legal descriptions, and contract law. And just for your information, I do have lots of videos in playlist, nationals for 2026, Texas state for 2026. Since I am in Texas, I do Texas state questions, playlist for vocabulary. So you'll want to review other videos to prepare for your real estate exam. If you like the way that I teach, I would ask that you tap the like button, okay? And if you're first time to my channel, hey, show some support, tap that subscribe button also. And the alert, if you click on that, it'll let you know whenever I go live. And anybody that might be new, I am a practicing realtor, and that's why I didn't go live yesterday, because I had a real estate appointments. So my goal is to do these Tuesday, Wednesday, and Thursday, 6 p.m. Central Standard Time. So that would be 7 p.m. Eastern Standard Time and 4 p.m. Western Standard Time, West Coast Standard Time. Any questions? Doesn't sound well. I appreciate you. Thank you for watching, and I'll see you on the next one. And remember, if you have any comments, post them on the comments in the chat, or after the video goes live. The answers will show up 24 hours after the video ends. After this session ends, the live, the chat will show up so that you can see all the answers as you go along. If you're interested in purchasing the book, there is a link in the description on the book that I used and some other ones. It'll take you to Amazon, and you can purchase it from Amazon. And I'm an Amazon affiliate, so I'll get paid a little fee. It doesn't impact your purchase price, though. So again, thank you so much. I love having you here, and keep studying every day to prepare for your real estate exam. If you didn't pass the first time, it's okay. Don't punish yourself. Pat yourself on the shoulder and say, hey, I went and took it. I was brave enough to go and take the exam. Now I know what I missed, if we remember, and I'll practice those questions or those terms or those concepts that I didn't understand and take this exam again as soon as possible. And why is that? Because we start to forget what we don't study, right? So just comment there. Make sure you relax the night before. Don't do an all-nighter. Know where you're going for the exam. And there's on my Facebook group called Lillie Handy Agent Prep, I do have some guides on there. So it has vocabulary. It has a cheat sheet for the night before the exam that could be very useful. Okay, so until next time. Oh, one last thing. Whenever you take your questions on your prep book or any book, keep doing the test until you score a 100%. The more you practice the same questions, the better you will understand them. Read the whole question completely before selecting an answer. And the exam, click the first 5 questions to check later because they usually get a person really nervous and sometimes they're the hardest. Look at the whole exam, click the ones you don't know, and then go back and review the whole exam again. Please do not change answers unless a future question helps you realize that a prior question that'll help. Until next time, catch you all later. Thank you for joining. Bye.